Good afternoon, everybody. Welcome to a very sunny London. My name is David Windcup. I'm a partner in the London employment team at Squires. We are going to talk today, the second of our series on whistleblowing. We're going to talk today about how the Whistleblowing Directive is being implemented in Belgium, France, and Germany. I'm going to be joined today by an expert team. There they are, and before you say, that poor man, why have they put him in black and white where everybody else is in colour? I do in fact look that grey and washed out, so that is a colour photo as well, so apologies for that. So a few housekeeping points to start. We have Marga from Brussels, Pauline from Paris, Tanya from Berlin. I'm going to begin with a very short summary of the UK position just for comparative purposes, but only very short because I'm not really here what you're here for. Housekeeping is this: all participants in listen only mode. If you want to submit questions, there is a Q&A chat function thingy that I don't understand, but do put your questions in there. We will get to them as we go along if we can. If we can't, and there is quite a lot to cover, then look out for the answers in our blog over the next couple of weeks. We will be recording this session. You will be sent a recording afterwards if once wasn't enough. Please feel free to pass that on internally. So we're going to do Marga first is going to give a brief overview of the whole directive, and then she's going to do Belgium specific points, and then Pauline and Tanya. But just to start with, this means for the first time, this directive, that it's probably not really going to be enough just to take the whistleblowing policy, and I'll rephrase that, it's definitely not going to be enough to take the whistleblowing policy that you have in the US or the UK and simply sticking a different badge on the top of it. The directive is very, very prescriptive around a whole range of different issues. It really highlights the difference in the way whistleblowers are seen as between the UK on the one hand and Europe on the other. In the UK, whistleblowers are treated essentially as a necessary evil. You get them, it's a bit like death and taxes. Everybody ends up with a whistleblower eventually, but they don't really, they're tolerated. It's nothing more than tolerated. Whereas in the EU, they are actively encouraged. They're seen as a force for good, as a force for compliance with the law, better business practice, and so on. So the principal distinctions you will hear is that in the UK, whistleblowers have only, if you like, negative rights. The right not to be penalised, the right not to be retaliated against. They don't have rights to determine the action that's taken in response to the disclosure. They don't have the right to determine that any action is taken at all. You would completely comply with the UK whistleblowing legislation by hearing the protected disclosure and saying, oh, that's lovely, and then doing absolutely nothing about it whatsoever. That isn't going to be the case in Europe. So here, no rights on the whistleblower's part to know the outcome, to determine the sanction against anybody guilty of anything, to be even consulted about that. So it's a very, very passive set of protections, but really no positive rights at all. The EU position is very different, particularly around feedback, timescales, and so on, just none of which has any place in UK law. So to help us understand whether any of this is really a good idea, I'm going to hand over to Marga, who's going to do a preliminary overview of the directive and then look at that again as it applies specifically to Belgium.
Thank you very much, David, and hello to everyone from a very rainy Belgium. The directive that David referred to was voted in Europe in 2019, and member states had 2 years to implement the directive. And that may be an important first starting point, is to say that the European legislator has effectively chosen the mechanism of a directive and not a regulation. And the difference is that with a directive, the legislator imposes a certain framework that is to be implemented still by the member states, where they still have some flexibility on how they want to implement in their national order. What is the aim of the Whistleblower Directive? The aim is to ensure a better enforcement of EU law. And the idea was there's things happening, there are issues of non-compliance with EU law, and we are not aware of them. And so if we provide a better protection to whistleblowers, that will make it that information on those compliance issues will come to the local authorities, and that will enable us to ensure a better enforcement of EU law. And that is important to understand, because that also defines the scope of the Whistleblower Directive, in the sense that what whistleblowers can report on is not just any issue, but it's only on breaches of union law. And so that means that it's the big ticket items such as product safety, environmental issues, food safety, protection of data and privacy. Those issues the whistleblower can effectively report on under the directive. But contrary to that, for example, if an employee wants to raise the issue that their boss is a toxic leader, as damaging as that can be, that is not an issue to be reported under the directive. Now, that's what the directive sets forth, but member states have the possibility to extend the scope of the protection to other matters. And it will be interesting to hear also from Pauline and Tanya to see what has been done in that respect in France and in Germany. Now, the aim is to provide a better protection to whistleblowers. So what is the personal scope of the directive? Who can make reports and thereby will be protected? Well, that scope is very wide. It's anyone reporting on issues that they have come across in a work-based relationship that they have with the entity. So that could mean employees, state officers, self-employed individuals, those who are currently still performing services for the company, but also former employees, for example, and even those who are just become acquainted with the company, for example, candidates that are in the process of recruitment procedure. They could also potentially blow the whistle on any issues that they discover around the company. Protection extends to the ones actually making the report, but also to the ones facilitating that report. That could be the ones that could be colleagues, that could be third parties that assist the whistleblower in making their report. Also, for example, by providing information that helps the whistleblower to make the report. And so who is protected? What is the level as from which you effectively get protection under the directive? That is if you have reasonable grounds to believe that what it is that you are reporting on is effectively true. So as soon as the whistleblower has reasonable grounds to believe that what they're reporting on is correct, they will get the protection from the directive. So how does it work? How does the reporting come about? Companies will be required to organize internal channels for reporting. In addition to that, there will be an external channel in every member state. And thirdly, there will be the possibility to select public disclosure if the other two means would not generate the required result. And so the directive in itself, when it comes to the choice of which avenue you need to take to make the reporting. The Whistleblower Directive is quite clear, and it mentions that it needs to be encouraged. So the member states need to encourage that whistleblowers use that internal channel. Ideally, you go through the internal channel first, and only if that doesn't generate a required result, only then can you go through the external channel or a public disclosure. And so it's only if the whistleblower feels that the issue will not be effectively addressed at the level of the internal channel, or if there is a risk of retaliation, that they can go for the second or the third option. On that internal reporting channel, these are mandatory for all companies that on average employ more than 50 employees. So the ones below 50 are off the hook. And that now there is a further distinction in the sense that you'll have to distinguish between companies between 50 and 250 employees and companies with more than 250 employees. If the company has up to 250 employees, they can share resources with other entities that also do not have those 250 employees. Regardless of whether those companies are part of the same group, they don't have to be linked. As long as they're below 250, they can share resources to receive complaints or reports and also to investigate them. And the reception of reports may be outsourced also to a third party, and that regardless of the size of the company. So also companies with more than 250 employees can outsource their the reception of reports. Now, there has been quite some discussion in that respect with regard to that threshold of 250 employees and whether or not companies with more than 250 employees could share resources to receive complaints, and for example, whether or not they can involve headquarters in the investigation of the report. That was a sensitive topic because what we saw was that it's mostly in those companies that there was already some type of whistleblowing procedure in place. Those were usually the companies that had already something that allowed reports to be made. And so the question was, would they have to, and very often for those companies, they would somehow involve, if they were an international group, they would involve headquarters to examine the complaint. And so the question was, do we need to do a complete overhaul? And do we effectively need to have something in place in each of the local entities? The question was raised with the European Commission, and they have confirmed they take a very strict position on the directive, and they have confirmed, no, unfortunately, if you have on average more than 250 employees, you will have to have an internal reporting channel, both for the reception and the investigation of the reports. But, says the European Commission, in addition to that, of course, you can have this additional layer, an additional possibility to report, for example, directly to headquarters. And you can even encourage employees to use this, let's call it international reporting channel. But at all times, the employee or the whistleblower should have the possibility to also report at a local level. The question was also raised whether you can ask headquarters to help you with the investigation. In that respect, the European Commission has also taken a very strict view, is to say this is possible, unfortunately, only for companies that don't have 250 employees. And again, you'll need to make sure that the whistleblower is aware of the fact that his information is being sent to headquarters. And if they do not agree, then you'll nevertheless have the obligation to investigate at a local level. On the process itself, David has already mentioned it, that there is a strict procedure, there is a strict timing to be complied with when for the reception and the investigation of the report. Within 7 days of receipt of the report, the channel has to confirm reception of the report. The report needs to be examined by an impartial person, and you need to make sure that the channel is organized in such a way that the information remains limited to the person or the persons who are dedicated to the channel, who are doing the investigation. So there can't be a disclosure to a wider group of people. And that investigation needs to happen on relatively short notice, because within 3 months after receipt of the report, you will have to provide feedback to the whistleblower. There's also information in the directive on the processing of personal data, and that's a good thing, because previously we didn't have that sort of legal basis to actually process personal data, which is inevitable if you're going to do an investigation following a whistleblowing report. So it's now good to have that basis in the directive, which confirms that, of course, personal data needs to be processed in accordance with the principles of the GDPR. And the directive also clearly mentions that if, as part of the investigation, you collect data that turn out to be not relevant for the specific topic on which the whistle was blown, well, in such case, you can't collect that data. And if you've nevertheless collected it, you need to delete it immediately. There's also an obligation for the companies to keep records of any issues that have been reported. As I mentioned, the aim of the directive is to offer a better protection to whistleblowers. That is a better protection against retaliation. Now, the definition of retaliation in the directive is very wide and can be summarized as a protection that's being offered to the whistleblower against any type of adverse impact that the whistleblower may experience as a result of them blowing the whistle. And the directive imposes on the member states the obligation to introduce into local law effective and dissuasive penalties to prevent retaliation against whistleblowers. So that, in a nutshell, is the directive. And it's in fact a good thing that I was asked to give you a brief introduction of the directive, because in a sense my work is done. In the sense that Belgium, and that is not the first time, has not been overly creative, has not been overly zealous in implementing the directive, and we have stuck very closely to the wording of the directive. No, not that many specialties to report on. So the fact that I've been able to give you this overview of the directive means that my work here is almost done. We took our time to implement the directive. The deadline was December 21. We needed another year, but we were by no means the last member state to implement it. But so in Belgium, there is now the Act of 28 November 22, and it came in force in February of this year. What are the differences, or what can I say to highlight the differences with respect to the directive, or where we have added things? Well, that is, for example, on the personal scope of the Act of 22. So as I mentioned, the directive allows whistleblowers to report on any issues of non-compliance with union law, but there is a possibility for member states to extend the protection. And that's exactly what Belgium has done, in the sense that we have added matters of tax and social security fraud, because we are somewhat notorious in Belgium when it comes to tax and social security fraud. It is considered by some to be a national sport. And so it made sense to add this, meaning that whistleblowers can also report on potential schemes of tax evasion, for example, that they are aware of, that their employer is endorsing. And that's the only extension, important extension, but that's the only extension that Belgium has included. On the personal scope, in Belgium, we've also stuck very closely to the directive, but we're even more explicit in extending, for example, the protection also to students and interns working in the company, and, for example, also explicitly mentioning that the employees of subcontractors may also report on issues that they detect at the principals. On the reporting channels, again, the directive is a very faithful execution of the directive. It would almost appear as if the Belgian legislature was blissfully unaware of the discussions that were taking place surrounding reporting channels and how they are to be implemented by companies with more than 250 employees, even though at the time the European Commission had already issued its opinion on the matter, and you're already seeing that Denmark, for example, was adjusting its legislation. There is no mention of this at all in the Act, not even in the preparatory documents. It's as if it has gone by unnoticed. In terms of the process, and nothing special to report either. What is interesting to note is on who should be managing the internal channel. So it's as mentioned, the directive requires that it be someone who is impartial. And then the question was raised as to which positions in the company would be suitable to also take on this additional charge of managing the reporting channel. And so what we do see is that it is mentioned in the preparatory works that, for example, someone like the DPO, the data protection officer, could be a suitable person to have that role of whistleblowing officer. Now, our Belgian data protection authority does not agree with this position and feels that there is a risk that if the DPO is appointed as the whistleblowing officer, that there is a risk of conflicts of interest being created. One issue that is important to mention is on anonymous reporting. So that was one of the areas where the directive leaves freedom to the member states to decide whether or not they want to actually impose an obligation to process and investigate anonymous reporting. Belgium has opted to effectively allow this and to effectively impose an obligation on companies to examine also anonymous reports. But this is an option for entities with less than 250 employees. So mandatory if you have more than 250, optional if you have less than 250, which is also a point that was criticized by our data protection authority because they feel that anonymous reporting should be discouraged as much as possible. A few items left. There is a strict obligation in Belgium to keep a register of any reportings that are being made. That register needs to be kept up to date, and you'll need to keep the information on the report in the register as long as the professional relationship with the whistleblower is still in force. So that's an extra formality that we have added in Belgium. There is as such the obligation under the directive to keep records, but in Belgium there is a strict obligation to keep a register of all the reports. On protection also, there isn't much to be reported, although we could say that in this regard, the Belgian legislator has been slightly more incentivized, and so we have quite an extensive chapter on the protection regarding the disclosure of confidential information. That's an important one because if someone is going to blow the whistle, quite likely they will do so on the basis of confidential information, whereas very often in other pieces of legislation, that disclosure of confidential information will have been prohibited. And so the Belgian legislator has been very careful to include the necessary references in this other legislation. For example, the Employment Contracts Act, the Code of Economic Law, to exclude liability for the whistleblower when they do effectively disclose confidential information. Now, in terms of what's at stake when companies infringe on the Whistleblowing Act and they nevertheless retaliate against whistleblowers, there's a series of sanctions. There is the possibility to impose criminal sanctions on the company. In addition thereto, the whistleblower can also claim damages, which for an employee can range between 18 and 26 months of salary on top of, for example, if they're terminated, that amount would come on top of their usual severance payment. If the employee works in the financial sector, the sanction is 6 months of salary to be paid. If the whistleblower is not an employee, then they will have to prove the extent of the actual damage that they have incurred, which you could argue is somewhat dissuasive to making complaints, because if you effectively have to demonstrate the damage incurred, that makes it more difficult for the whistleblower to be compensated. We've also introduced the reversal of the burden of proof. So it's if an entity, if a whistleblower makes it credible that effectively the retaliation that they have suffered is the consequence of them blowing the whistle, then it's up to the entity to demonstrate that in fact there is a justification to the negative measures that were taken that is not related to them blowing the whistle. That in a nutshell, and I see that I'm just within the time that I was allocated, is the situation in Belgium. So I will now leave the floor to Pauline.
Hello, everybody, and thank you very much for listening in. I'm going to do a brief overview of the French aspects of this whistleblowing policies and new legislation that was put in place in 2022 in respect to the directive. So first, a little zoom out. Whistleblowing is absolutely not new in France. It's been there since 2016, and we already had, France already had whistleblowing protection measures that were taken in the context of a law called Loi Sapin 2. But since 2022, new legislation has implemented the European directive from 2019. What has changed? So what has changed is that not only has the number of, well, the beneficiaries of the right been extended, but there's also been an extension of the protection of the whistleblower. So is considered as a whistleblower any person that signals or divulges without any financial counterparts and in good faith information pertaining to a crime, a threat, prejudice for general interest, violation, or tentative dissimulation of a violence or of any international engagement or treaties that have been ratified by France. And this also could be a unilateral violation of a French law, European Union directive, law, or regulation. So any individual without any financial counterpart. So that is the new aspect of the 2022 legislation in France, is without any financial counterpart. Before that, it was in good faith. So we didn't know who could really be a whistleblower. Could it be someone in conflict with their employer or not? Well, the case law had said no, and now they say yes, because as long as there is no financial counterpart to divulge in information, you're a valid whistleblower. So that in that sense, it has been extended. So that is the first point. What are the obligations on companies to implement whistleblowing channels? So that has also existed since 2016, but there are new elements brought in 2022 with regards to group-wide reporting channels. So what is the state of the obligation, generally speaking, in France? Internal procedures are put in place in any business mandatorily that when they have 50 employees or more. And the businesses, the companies have to implement internal procedures to receipt the treatment, the signaling, the issues that are raised by whistleblowers, and these internal processes have to be implemented after consultation with the applicable works council, the works council and in the company. For employees with less than 250 employees, this process can be, as Marga has explained, can be put in common with other entities, whether they are part of the same group or not. So in this aspect, it's entirely in conformity with the European directive. The internal process is it has to contain specific information. First of all, it has to say that the the whistleblower has to be free to report or not any violation that they may see fit, and the process must indicate the people, the services, the internal divisions that are responsible to put in place that internal process and to receive those alerts. These persons, they're not defined. The services, the divisions, the persons within the company, they're not specifically defined. However, they have to receive specific training and they have to have adequate means to receive and treat the information. The internal process it instaurs a alert procedure and it allows alerts, whistleblowing, to come through either in writing or verbally. So it can be a hotline, it can be a conversation in person, or it can be via, the very classic process of web reporting within the business. The division, the people receiving that alert have the obligation, and that's also a change, have the obligation to confirm receipt and eventually ask more information in the 7 work days after receiving that complaint. And they can either seek more information about the whistleblower. They can say eventually that due to insufficient information, there can be no further investigation. And when whatever was raised, whatever issue was raised is significant enough or gives rise to an investigation, the company has a 3 months time period to continue investigating and figuring out, what to do with that alert. The alert process and the alert, the whistleblowing protection needs to be recorded, reminded in the internal regulations, what we call our règlement intérieur. So what matters can be reported on? So the whistleblower can pertain to any act which is forbidden by law, any crime, and any threats that any events that can constitute a threat, as I had previously explained. And once again, whistleblower is also a more expanded definition. Why? Because it's not only the person who personally experienced, saw, noted the violation and wants to signify the alert, but also the immediate circle of the whistleblower, which can suffer from consequences or pressures or professional disruptions tied to the whistleblower. So it's directly the whistleblower and the immediate circle, whether professional or personal, who can be retaliated upon due to this whistleblowing situation. Are companies required to follow up on anonymous reports? Anonymous reports are possible in France. And so, yes, anonymous reports will be followed upon in the same conditions and in the same terms as I have stated before, in the 7 days and 3 months to continue the investigation. You don't have to request for the person to identify themselves. It's only if you find that the anonymity is suspicious or doesn't allow to take the whistleblowing seriously that it could be excluded. Um, but you know, it's not per se forbidden, but it's of course not recommended, but it's not forbidden. And follow up. The first follow up is necessary. Now we have something which is entirely new in our procedure, which is the external report. So before, we had a very specific process where now first you had to do an internal alert in your company or within your administration if you're in public service. Second, when you had no response, no treatment, you'd go to the French administration or judiciary system to further that whistleblowing. And third, if no response was given, you could go to a public disclosure and become a public whistleblower. Since 2022, the whistleblower can choose whether to make an internal disclosure, an internal whistleblowing, or an external whistleblowing. So that's either or. You don't have to go through the 3-tier which I explained earlier. And then the whistleblower could make a public disclosure or a public whistleblowing procedure only after having done an external whistleblowing, so a whistleblowing towards an administration or a judicial instance, when there's been no response, when there is a risk of retaliation or a risk that the whistleblowing report is not followed of any effect. And in any event, first and foremost, in case of imminent and serious danger, there can be a public whistleblowing process made. What is the protection for the whistleblowers? So really, I mean, it's very similar to the description made previously. The whistleblower is and their facilitators. So the whistleblowers, their facilitators, meaning if they're held by their union, that's also an arm's reach or covered by the whistleblowing policy protection, have a disciplinary immunity, are not to be held liable for damages that have been caused by the necessary whistleblowing that they have made. They are not criminally considered as accomplices to or even responsible for violation of trade secrets if they had to reveal some of information to make their whistleblowing policy. And they are also protected against unfair retaliation, such as threats to cut access, cut their internal or external access to communication, so email, etc., or even threats made against their psychiatric sanity. Well, basically their sanity. Just they're protected against threats made to the credibility of their whistleblowing. And of course, the state is responsible for enabling psychological and financial support of these whistleblower where necessary. Especially when the alert comes through directly to the administration, that administration is supposed to give sufficient financial needs for the whistleblowing to continue its way through. And that's where I think here the distinction is a little bit more visible, because are there any sanctions for non-compliance? The reality is that if you don't put in if your company doesn't put in whistleblowing policies or internal processes that I've just described, there is no direct sanctions. However, the reality is that it's really in case of labor law litigation that if you don't have the appropriate anti-retaliation and processes in place, that you find yourself in difficulty because you find yourself in violation of the basic protection you owe to your employees when it concerns your employees, and that the employees could consider that their employer has not respected their general safe workplace obligation towards them, because in France, employers are supposed to provide a safe and healthy workplace to their employees. And when you fail in protecting whistleblowers or having the adequate processes, that can be a violation of labor and employment law regulations. So that's where the criminal the sanctions here would be direct. Now, of course, there's civil fines for abusive whistleblowers, but that's always existed. I'm looking at it through the prism of what's the risk for companies not complying with their obligations. And can labor courts also order employers to contribute to the whistleblower's personal training account? So when there's been, that's really a very French specificity, when the employee finds the whistleblower employee / finds itself without a job or having been retaliated upon, on top of all the labor law and employment law sanctions, which will have been imposed on the employer for unfair dismissal, discrimination, all the classic labor and employment regulations. The employee may also benefit from a specific sum of money placed on their training account, so they can maybe entirely retrain to become something different or have a new career and move away from that whistleblowing domain, which will necessarily affect their career after they have switched employers. So that's something very French and very specific with regards to whistleblowing. And on I go to Germany.
Yeah, thank you very much. Pauline. I say hello to everyone. Thank you for joining this webinar here. Yeah, we heard a lot about Belgium and France, and in Germany it's similar, I would say, what happened in France, and of course what will maybe happen in Belgium to implement the Whistleblowing Directive. As you all know, maybe you saw it in the press, here in Germany we had huge discussions prior to the implementation of this act. There were discussions if it is possible for a whistleblower, for example, to make a report to an external channel, a reporting channel, and also to an internal, or is this not possible that, for example, an employee has to contact the internal channel? However, the other aspect was anonymous reports. Is it possible or not? However, we made it here. We made our homework, and the new act, the name is the Hinweisgeberschutzgesetz, passed by the German Parliament on the 12th of May and will come into force on the 2nd of July 2023, so in the near future. What does it mean? Some companies, of course, have to speed up the implementation of this internal reporting line. And similar to the other countries here, Belgium and France, the new act, or France is it already implemented, but the new act will require all companies with at least 50 employees to establish internal reporting channels. And some sectors here, it's independent from the number of employees. For example, the finance sector or for insurance companies. There is an obligation to have such reporting lines independent from the number of employees. Companies with 50 employees up to 249 employees have a time period until the 17th of December 2023 to establish these reporting channels, whereas companies with 250 employees and more have to implement these reporting channels until 2nd of July 2023. So they have to speed up. And I just want to flag one aspect here. Due to the fact that we also have, like in France, works councils, there are co-determination rights which might apply regarding the implementation of such internal reporting channels. So if you're planning to insert such a reporting channel, for example, in your company, but also if you forward it to an external party, then of course it is important to always keep in mind the co-determination rights. It could happen, and that based on Section 87 of the Works Constitution Act, you need the prior consent of the Works Council, and the Works Council, of course, can postpone the whole process of the implementation. Regarding the new act here in Germany, and it's still sometimes, you know, if foggy, there are still many discussions how to interpret the new act. There are not a lot requirements for an internal reporting channel in detail. Of course, the internal reporting channel must allow reports to be made verbally or in text form. Oral messages must be possible by telephone or other voice transmission. If requested by a whistleblower, a personal meeting with a person responsible for dealing with these reports at the internal reporting channel must be made possible within a reasonable period of time. So it is not possible here in Germany to postpone the whole process and just say, we do not have any time or whatever. And besides this, as Marga and also Pauline also described, we have a clear procedure what will happen after a whistleblower made a report. So there is an obligation to issue a receipt within a time period of 7 days. Then, of course, it has to be assessed if the report is in the scope of Section 2 of the Whistleblowing Act, meaning by is this really a violation which falls under the Whistleblowing Act? And then the person who is dealing with this report, of course, has to make further assessment and have to give a feedback to the whistleblower within 3 months after the acknowledgement is received of report. And regarding this feedback, it should, of course, include also action which has been taken, and the notification are to be documented in compliance with the confidentiality requirements here under German law. In principle, if, for example, an investigation is closed, all the documents must be deleted after 3 years if there is no reason to keep them. So it is here in Germany still a clear process, which is in line also with a European requirement. But of course, what is also important is that there is the person who is dealing with the reports of these whistleblowers must be an independent person. So it is important that he or she is not in conflict if she is assessing the issue, and there is no obligation here in Germany to hire a new employee who is dealing with these reports. I think this is important for you to know. However, if the company is interested in hiring an employee who is dealing with these reports, then of course you have to think about the co-determination rights of the Works Council because you need the prior consent of the Works Council for this person. The question if it is possible to implement group-wide reporting channels. This is here in Germany, this is possible under the German Act, but however, it is questionable if this can be challenged because it might be too wide how we implement it here in Germany. What matters can be reported to also in Germany. We extended the scope of the Whistleblowing Directive and included reports about criminal offenses and reports concerning certain administrative offenses. And these offenses are, for example, the violations which are subject to a fine if the violated regulations service to protect life or the health or protect the rights of employees, or, and this is also very important, the rights of the employees' representative bodies. This is also possible that this falls into the scope of the Whistleblowing Act. So this means that, for example, a violation of the Occupational Health and Safety Act, violation of the Minimum Wage Act, Leasing of Employee Act, or violations violations regarding the obligation to provide information to the Works Council, Joint Works Council, or Group Works Council might violate here or might be in the scope of this Whistleblowing Act. Are companies required to follow up on anonymous reports? Yes. Yeah, we had huge discussion regarding this issue, but there is an obligation here in Germany to take care also of these anonymous reports. Can a whistleblower make external reports? Also a huge discussion here regarding this act. Yes, a separate unit is to be created at the Federal Office of Justice, which will be responsible for the receipt and proceeding of reports from whistleblowers. And it is possible that a whistleblower can make an external report with or without a prior internal report. And I think to avoid external reports, it is important that you train your employees of your company that it is, of course, better to make internal reports, that you can deal with it before they contact an external reporting channel. What about public disclosures? Whistleblowers who publicly disclose information will only gain protection in a limited circumstance. So it is possible, there is an obligation also for these whistleblower to contact the internal or external channels before they publish it here. And what is also important for you to know is that only if the employer, for example, or the external channel will not do any or will not fulfill their requirements, then of course it might be possible for a whistleblower to go public. However, what protection is there for whistleblowers? Here in Germany, the whistleblowers based on our German Act a very high protection. It is not possible, for example, to dismiss an employee because he made a report. It is not possible to give him a warning or to or whatever, relocate him or her into a different department. This is not possible. However, it could also happen that a whistleblower may be entitled to damages. It depends if there are some damages, and he can also claim against the employer for damages. But of course, if the report is wrongful, if it is not correct, and the employee is aware of it or could be aware of it, then of course there it's also possible that the employer files a lawsuit against this whistleblower who is reporting false information. I'm running out of time here. I have only 1 minute left, I see. So here on my last slide, you can see that, of course, we have also implemented sanctions and fines here in our Whistleblowing Act. In the beginning, we had a discussion that the fine should be up to 100,000 euros. Now it's limited to 50,000 euros. If, for example, a company does not implement the internal reporting line or channel, then there will be or might be a fine of up to 20,000 euros. But this fine regarding this implementation of the reporting channel will come into force at the 2nd December 2023. To give the companies a little bit more time before there will be a fine regarding the implementation. But however, there are also sanctions if, for example, an employer makes any sanctions against an employee. There could be also an obligation for this employer that he has to pay a fine because he put pressure or did anything against the whistleblower. So there are high sanctions here in Germany. So it's 1 minute after 2. I think
All right.
1 minute late.
Thank you all very much. Thank you if you've listened in for that. We had a grand total of 1 question through the Q&A, which is perhaps the obvious one, which is, given all these rights and obligations and so on, what are the employer's protections against, frankly, the abuse of this as a piece of legislation, as it is possible to say has been the case in the UK. Now, we don't have time to deal with that today, but I will promise to speak to each of Margaret, Tanya and Pauline over the next week or so, and we will put something on the blog to address that question. Otherwise, that brings our webinar today to a close. Thank you very much. We will be circulating the slides and a recorded link, so look after that. This time next week, we will be hearing from Italy, Spain, and certain parts of Central Europe on the same question. So do look forward to having you back for that. But for present purposes, thank you very much. Good afternoon.
Thank you.
Thank you.
Bye.